This case was rendered uh, on February of 2022, and the appellant in this case is the Serious Fraud Investigation Office under the Ministry of Corporate Affairs, uh, which is constituted as per the Company Act of 2013. And the appellants are Rahul Modi and another person. And it was rendered by Justice J. Nageshwar Rao in Civil Criminal Appeals of 185 186 of 2022. As evident, the main question of law which has been put forward in this case is continued uh, whether the accused has to be again placed under the custody as per 167 clause 2 if the charge sheet or the complaint etc is filed or the cognizance of the complaint has not been taken. If it is not taken, whether they can be placed under the custody for the mere fact that the complaint was filed or the charge sheet was filed, which was placed in the open forum in this case. We know from the facts of the case, it is well known that both of them were arrested by the director SFIO on 2018 December. Later, on a writ petition filed, Delhi High Court had ordered release on them, and Supreme Court later set aside the Delhi High Court's decision on 27th of March 2019, and based upon which on 1st of April they surrendered and they were remanded to 14-day judicial custody on 5th of April. Special court extended the judicial custody to again on 6th to 16th of May 2019. Then respondents in this case, that is Rahul Modi and the other, applied for regular bail on 3rd of May 2019 before the High Court. So on 3rd of May, they have completed 30 days. And then the High Court listed the matter on 21st of May 2019 and also ordered the trial court to consider their application as per Section 167. Trial court on 16th of May 2019 extended the remand to 35 2019. It is pertinent to note here that the High Court directed the matter to be listed on 21st of May 2019. And just before that day, that is on 20th of May 2019, 20th of May 2019, the respondent filed application for statutory bail under Section 167, Clause 2 CRPC before the trial court. And the sessions judge dismissed the application on 22nd itself, citing the reason that the complaint was filed on 18/5/2019 by the uh, appellants in this case, that is SFIO, uh, as per 439 clause 2, read with section 212 clause 15 of the Companies Act. And so it was filed well before the 60-day statutory period, and hence they are not entitled to bail. This was the contention of the sessions judge. So High Court, while taking the matter on 31st of May 2019, said to ordered release of the accused and cited that the trial court failed to take cognizance of the complaint before the expiry of 60 days. Now, that is the point where the discussion starts. Now, Assistant Solicitor General, appearing for the SFIU, has put forward that the High Court committed a serious error in granting bail in spite of the fact that the complaint was filed well before 60 days. High Court committed an egregious error by holding that cognizance also must be taken before the expiry of 60 days, else statutory right for bail. He submitted that on completion of investigation and filing of report or complaint under 173 clause 2, statutory bail of 167 clause 2 can be availed if the investigation is not completed within the prescribed period. Now, he also, Additional Solicitor General also pointed out that if the decision of the High Court is going against Suresh Kumar Bikram Chand Jain versus State of Maharashtra and another, which is a decision rendered by the Apex Court. Now, with that, the contention of the ASG ends. Now we go for respondents. The respondents placed their contention on Sanjay Dutt versus State case, and they argued that the maximum detention period is 60 days in the present case, beyond which it is not possible if the accused is unable to furnish bail then the remand is possible, otherwise it is not. And also cited another case, that is Muhammad Iqbal, Madar Sheikh, and others versus State of Maharashtra, and they contended that the right under Section 167 Clause 2 cannot be exercised after the charge sheet is filed and cognizance is taken. So, accused has the right to seek statutory bail even after the charge sheet is filed till the court takes cognizance. So, that was the contention from the respondents. Now, the intervention application by an intervener was also allowed in this case, and he cited by the means of Mokul Rohatgi advocate, he cited the Mother Sheikh case and said that the cognizance of complaint should be taken before the expiry of statutory period from the date of remand. In Bikram Chand Jain case, the court has taken a different view. In M. Ravindran versus Intelligence Officer, Directorate of Revenue Intelligence, the court took the same view as that of the Mother Sheikh. He cited similar case such as a criminal appeal of 701 to 702 of 2020 and SLP criminal number 2111 of 2021, which also raises the same issue. So Rohatji submitted before this court to refer this issue to a larger bench. So with that, the intervener's arguments also comes to an end. Now the court uh, takes up this issue in its metrics. That is, the respondents are accused of committing offences of fraud as per Section 447 of the Companies Act and 120B, read with Section 417, 418, 420, 406, 463, 467, 468, 471, and 474 of IPC. The trial court dismissed application under Section 167, Clause 2, citing charge sheet has been filed before 60-day period. Now the court goes on into deep into the Bikram Chand Jain case. In the Bikram Chand Jain case, the petitioner was arrested on 11th of March of 2012. His contention was that he was entitled to bail as he was a public servant and he was arrested on certain specific charges of misappropriating funds meant for some certain development project, and he was contending before the court for that he is entitled to bail as the sanctions required for prosecuting him for taking cognizance against him was awaited, and so the investigation could not be carried out within 90 days. In that case, when investigating agency failed to complete investigation within prescribed period, accused acquired an indefeasible right to grant bail. So once charge sheet gets filed, right of statutory bail comes to an end, and so accused can pray for regular bail on merits. That was some of the decisions which were some of the observations that the court made in this Vikram Chand Jain case. The court held that filing of charge sheet will suffice. Court has held that filing of charge sheet will suffice the Proviso A of 167 Clause 2 requirement, and the cognizance is immaterial. That was the uh, main contention that the court took here, and this sole decision is the point where this case ends. Now, the court goes further for explaining certain other phenomena also. Now, the charge sheet is filed before 60 days or 90 days. If it is not filed within 60 days or 90 days, on the 61st day or the 91st day, as the offense charged against depends upon the accused gets the right of getting bail, statutory bail. If it is charge sheet is filed, then the accused has to remain in some form of a custody of the court until the cognizance of that matter is taken by the court. So, under section 309 of CRPC. So, that intervening period custody is essential. And that is the point here, that is the importance of this point here. So, this legislative intent of 167 clause 2A requirement, if it is met, then the accused is entitled to bail. If it is not met, then the accused has to remain in the custody for further investigation of the offense until the court takes the cognizance in this matter. Now, the court clarified its view in certain other cases which was raised by the opposite side. That is, in Sanjay Dutt's case, the court had held that the custody of accused after the challan has been filed is not governed by Section 167, Clause 2, but different provision of CRPC. In Madhur Sheikh, the appellant was taken on custody on 16/1 of 1993. The charge sheet was filed on 30th/8 of 1993. In this case, the appellant did not make any application under Section 167, Clause 2 of CRPC. So he did not furnish an application in this case. So his matter is different. And in M. Ravindran case, he was arrested and remanded to judicial custody on 4th of August of 2018 under NDPS Act. And he was given bail on 1st of February 2019 under 167 clause 2. The Madras High Court set aside his bail by a judgment of 21/11/2019. Here, bail application was filed. Here the peculiar issue is in M. Ravindran case. The bail application was filed before the court at 10:30 a.m., but the additional complaint was filed at 4:25 a.m. The court held that once the accused is deemed to have availed the right of statutory bail once an application under 167 clause 2 is moved. And so there there's no it is immaterial of you filing another complaint or charge sheet after an application of 167 clause 2 is filed. So it's we can understand from the basic what you can say from the basis of that judgment itself that abuse of authority is restricted by the court from a plain understanding of that fact. Now, in the case of criminal appeal of 701 of 2022, the question was whether the period of remand has to be included in computation of 60 days or 90 days. So it was passed to a larger bench. Now we come across some certain cases where in 167 clause 2's relevance as per, we have already discussed two cases in the Ganji Reddy case. While we were discussing Ganji Reddy case, uh, I had placed two judgments. That is, one was M. Ravindran case, and the other was Vikram Jit Singh case, I believe, in which the 167 clause 2's relevance was pointed out. The 167 clause 2 gives us an indivisible right, and it is part of the procedure established by law under Article 21. That was the importance which was attributed to this 167 clause 2. That is a constitutional uh, importance was attributed to 167 clause 2 in that particular case. So some other judgments in this. We know there are under trial prisoners in this country. So on the basis of which the Supreme Court in Husainera Khatun versus Home Secretary of State of Bihar has said ordered the release of under trial prisoners whose period of incarceration had exceeded the maximum period of imprisonment for their offences, and pointed out to the failure of magistrates to respect Section 167 Clause 2 CRPC for not ordering release on the expiry of them of 60 or 90 days. In Abdul Rahman Antule versus R.S. Noaid, Supreme Court had laid down guidelines for speedy trial in all courts across the country. And Supreme Court inter alia observed that right to speedy trial flows from Article 21, and it encompasses all the stages, namely investigation, enquiry, trial, appeal, revision, and retrial. The worry, anxiety, expense, and disturbance to his vocation and peace resulting from an unduly prolonged investigation, inquiry, or trial should be minimal. 167 Clause 2A CRPC allows such accused to remain in custody until he is able to furnish bail. That is another thing. That is another thing. That is 167 Clause 2A allows that person to remain in custody until he is able to furnish a bail. In that case, also, in a Delhi High Court decision in Lakshmi Narayan Gupta versus State had said that where accused person is in judicial custody and if he is poor, directions must be passed for admitting him to bail. Now, lastly, this is the last point which I would like to say. That is, Law Commission of India, in its report number 268 on Amendment to Criminal Procedure Code of 1973, which is provision relating to bail, on its May 2017 report, has proposed an amendment to Section 167 Clause 2. Here they put for a term not exceeding 15 days in the whole, the words for a term not exceeding 15 days in the whole, excluding the period for which the person accused of an offense is not available due to hospitalization or otherwise shall be substituted. So, the abuse of Section 167 Clause 2 from the part of the authorities as well as from the part of the victim, sorry, from the part of the accused is taken care of. And if this recommendation is accepted, then the abuse of that provision of 167 Clause 2 by the accused will also be curtailed. Now, lastly, I would like to stress upon a recent judgment of the Supreme Court in C. Parthasarathi versus Directorate of Enforcement dated May 17 of 2022. It has held that the an incomplete charge sheet filed without completing the investigation cannot be used to defeat the right of statutory bail under 167 clause 2 of CRPC. That is, if you are filing a charge sheet, it should be a complete charge sheet. You cannot plead incomplete investigation before it. So mere filing of a charge sheet, as mentioned in Madhur Sheikh case, will not, sorry, Bikramjit Singh case, will not, what you can say, uh, deny the accused the statutory bail. It should be a complete charge sheet. That is what it is observed in C. Parthasarathi versus Directorate of Enforcement. So these are my views in this case. Thank you so much.